welcome to Oberti Sullivan's second video cast. The first was so popular we thought we'd try it again. Continuing on with our explanations of the top 10 employer mistakes made by employers anywhere, not just in the state of Texas. I'm Ed Sullivan.
I'm Mark Oberti.
And we're here for tips number 3 and 4. The first thing we should mention to you that is this is for general legal education advice, and no attorney-client relationship is created, but we hope you enjoy it. So let's first talk about disasters in documentation, Mark, which is our next top 10 mistake.
Yeah, there's so many, Ed. Let me start with our first bullet point, which is desk files. And that's, of course, the file that supervisor sometimes keeps of little what he or she thinks to be helpful notes to document the perpetual problems of the employee who later becomes a plaintiff. And although the supervisor may be well-intended, oftentimes what we find is that that's basically like manna from heaven for the plaintiff's lawyer, because the plaintiff's lawyer will quickly interpret that or argue that as, number one, not a legitimate effort to document the plaintiff's performance problems, but rather to build a file behind their back. Number two, it's easy for the plaintiff's lawyer to say, the reason the company has typically progressive discipline and encourages sharing with the employee their failures and giving them an opportunity to improve is to have that sort of open dialogue, and a desk file is kind of the contrary to that. And then number three, you'll find very often the plaintiff in deposition or even at trial will say that whatever the person put on the desk file as a problem, I remember a case where the manager said, well, they were late to work, and then of course the plaintiff said, well, yeah, I was, because my close relative was dying of cancer, and I told my boss that, and my boss told me that I could come to work late that day, and so I'm just flabbergasted and shocked and frankly stunned that they would actually make a note saying I was late to work. So for all those reasons, we're against the desk file approach.
And by the way, for those at home, I should have mentioned this earlier, you can actually find a copy of this presentation at our website, www.osattorneys.com/presentation. And I think that the modern equivalent of the desk file is the particularized email folder for employees on Outlook. You start to see that now where bosses only save emails related to one or the other employee, and it looks really bad. It's fine to save emails, it's fine to put them in a personnel file, but to sort of single out individuals for this behavior is where you're going to run into a lot of those problems. Another one of the problems that you see, however, and this is frequent, where an employer will call a lawyer or someone and say, let's terminate this person, we should terminate, or even after the termination occurs, and you find absolutely no documentation either building up the reasons for the termination or the events that occurred to this particular or the decision in the termination. And that's bad. And that's bad for a lot of reasons. Mark, why don't you say why you think some of the reasons are bad?
Well, I mean, it's as simple, kind of at the core, the courts have repeatedly held that if you fire an employee, for example, for poor performance, but there is no documentation to establish that poor performance, and this kind of leaps forward 2 dots to our padded performance reviews, is oftentimes there'll be performance reviews and they don't show poor performance, and there's no other documentation of poor performance. And there's been a lot of case law from the Fifth Circuit and even recently some district courts here in Houston that say, well, if you don't have that sort of documentation, you're just making up stuff after the fact. A jury can reasonably infer pretext, meaning that the real reason is the alleged illegal reason. So that's one of the main reasons that not having documentation as the basis for a termination is a really bad thing for an employer.
Another thing that, this sort of gets into is just having documentation of harassment or investigations related to that. Because as a lot of people may know watching this, the Supreme Court basically said, and we talked about this in our last video cast, that there are affirmative defenses that employers have if an employee brings a claim of sexual or racial harassment. And particularly that, the company has to have a policy against sexual harassment, and they have to take reasonable and prompt effective method to, do investigations of harassment claims. And in this case, if you say you've had an harassment investigation, but there's no investigation notes, that the person doing the investigation can't show you what he or she did in terms of documenting it, there's no documentation in terms of discipline, if any, that were involved, it's going to be extraordinarily difficult, since the burden of proof is on the employer to prove that defense, because juries might rightly think, oh well, they're just making this all up after the fact, just like what Mark was talking about on the no documentation.
For sure. And then we talked briefly about padded performance reviews, and there's been books written about this. The bottom line is you really need to train your managers, and this is one good reason to have training, is that what they put on a performance review, they're going to have to live with. And so many times you've probably had to experience where a manager says, oh, we have to get rid of so-and-so. Well, why? Oh, their performance is just horrible. Well, what about the last review you gave them 3 months ago? It says, even if it doesn't say great, if it says satisfactory, jurors believe satisfactory means that's a satisfactory employee, no hint that they're about ready to get terminated. So that padded performance review is going to be a big benefit for the plaintiff if you fire them for poor performance, and you've padded their performance review recently. And lots of employers have tried to convince juries that, oh, we didn't, we were kind of exaggerating a little bit because we're nice. That's a hard sell to a jury to convince them. You might tell a little white lie in order to make the plaintiff feel better. Well, what might the jury think you might say in order to avoid liability? So padded performance reviews, another huge problem, and best way to address it is just don't do it.
Well, there's a theme that Mark essentially just raised in that last bit, and the bit is this: any document that is going to be created during an employee's employment with a company, and if that employee eventually sues, that's a discoverable document, meaning that the other side has access to it, and meaning that a jury may very well see it. And in that vein comes the mean-spirited memo, the idea of a supervisor writing something out just to be a gotcha, or just to look like a jerk or catty. Now, they may very well have valid, legitimate reasons for wanting to write it. They feel betrayed by this employee. This employee's personal performance has been, lackluster at best over times. And I understand, we've seen these memos time and time again, but creating these sort of mean-spirited language can be really detrimental in defending claims. And it's very important, I think, to train your supervisors on the idea that anything in writing, anything, even though there's no threat of a lawsuit at the time, no one thinks about a lawsuit, you should put in the back of your mind the emails that I'm writing, the memos that I'm writing, the progressive discipline, the disciplinary write-ups. Will that ever be in front of a jury? And if it is, we want to be the guy wearing the white hat at the time. We want to look like we were always taking the steps to improve performance, to be proactive, and to help that person succeed.
Absolutely. Couple points on that one real briefly. Was one, your supervisors have to understand if this person's been a perpetual thorn in their side and they're just a bad egg, they may know that, but it's very hard to show a jury from that supervisor's perspective what that person's really like. The second thing is, sometimes I see it's really not mean-spirited intentionally, but when you just look at the words on the paper, it is. Common example is you have somebody who's not at work claiming a medical problem, and I'll see people fire off a letter saying, you haven't been at work, your attendance is inappropriate or not acceptable, and if you're not back soon or you don't tell us the reason why, you could be terminated. And then if it turns out the person really did have a serious medical problem and they show that letter, it's easy to portray the company as somewhat callous, even though there was no meaning for it to be callous. So just taking a little extra time to look at it from the human lens, you can avoid this problem. And then the next problem, as going to talk about, is position papers that companies submit.
Sure. Well, this is really a problem that occurs in documentation after the beginning stages of litigation have already occurred to some degree. If an employee has filed for unemployment, or the employee has gone to the EEOC, and there's an actual opportunity for the company to be heard on one matter or the other, companies got to remember the position that they're going to take before a government agency is going to stick with them. And if they shift off that position, well, then that's going to be pointed out to a court as well as a judge or a jury. That's going to be very detrimental if the company changes its story in midstream. Now, sometimes the story changes because there are more facts brought to light, and that's just the right way to do it. But the problem could have been averted had someone at the beginning tried to develop and get as much information as possible to provide full and accurate information to the governmental agency. I can easily see where it's an innocuous one-sheet piece of paper. It's just asking for some information, and one person, not really in the know, just picks up the phone, calls a supervisor, says, what was the reason for termination? What was the reason here? and takes a quick 2-sentence answer, puts it in a document, and sends it on to that governmental agency. But a thorough investigation, and I don't mean dedicating days and weeks of your life, but someone has to be reasonably confident that all the facts are given to these agencies so they can have the full picture.
And same thing with unemployment hearings. If you're going to do them, Ed and I have both gotten calls from clients in the past. In the middle of a hearing, they're calling us now, panicking because the employee has a lawyer and the lawyer is examining their witnesses and their witnesses maybe weren't fully prepared. And this is all under oath, and it's all being tape recorded, and it can all be brought back up again. So if you're going to do the TWC or the unemployment hearing, you may not want to, but if you do, and sometimes you should, because there are occasions where it's right to fight that unemployment claim. But if you're going to go into it, make sure your folks are prepared. Don't go in there and just be a sitting duck.
Back on the sort of theme that everything you say is going to be used against you, which it is. It's in written form. I mean, think about LinkedIn. LinkedIn is a very common social media website. It's used by employees all over the United States, if not beyond. And it has a recommend feature. And LinkedIn actually encourages users to use this recommend function. And you'll see a lot of times, and we cite a case in our paper, but the long story is if the employer is going to talk about what a bad employee is or she is and make points about that employee, well, check those LinkedIn recommendations. A lot of times that employee will be gone, ask for a recommendation, and some supervisor or manager will write this great recommendation. And that's going to be used against that company in ongoing litigation.
For that reason, it's a good idea. Most companies have reference policies about who has the authority. Include LinkedIn in that for sure.
I agree. Long story short, I think on documenting tips, make sure that supervisors know about the importance of maintaining documentation, maintain uniform forms and rules for documentation. And it's real important that when something gets documented, that it not be nitpicky like, you wore the wrong color, button here today, but make it stuff that juries are going to actually care about.
Yeah, something that vindicates a compelling purpose of the employer. And the last bullet point on the slide that we've got pulled up in our presentation is a good one too. Sometimes somebody's not going to make their performance improvement plan. Don't start that termination paperwork till it's a done deal 100%. Otherwise, it can be turned around on you like the plaintiff turned it around on Xerox in this case from the Fifth Circuit in 2010, where the Fifth Circuit affirmed a jury verdict for the employee.
Our other topic, which won't take us too long to talk about, but it's our fourth sort of mistake that employers make, is not following company policies without a good reason. And I'll let Mark expound on it. But in general, companies that promise to do things in handbooks usually get themselves into trouble. But having a policy about termination of employees and not following it can be devastating. Mark?
Yeah, two examples. Sometimes companies will say in their reduction of force policy, well, this is how we're going to have a reduction of force, maybe seniority or whatever it is. Well, I remember a case where it did say we'll file seniority, and then they didn't follow it. And there was no legitimate reason, no articulated reason, just an oversight. That's a hard thing to ask a judge or jury to forgive, violating your own policy on something that important. Doesn't mean they couldn't have done it, but they should have thought about it intentionally, documented why they're doing it, and they could have done it. So RIF issue, look at your own policy before you start pulling the trigger. Second thing is this Smith versus Xerox case example where the manager was nitpicking allegedly this long-term high performer who filed an EEOC charge and issued some sort of documentation critical of the employee. And the HR manager even said, well, you're not supposed to do that unless you've gone through these counseling steps further. And even the Fifth Circuit said that's evidence of pretext in that case. And so not following your company policy without a good documented reason is a sort of trick that plaintiffs' lawyers like to pull out and show as evidence of pretext.
All right, well, it was fun. We appreciate you watching us, and we'll be back with 2 more tips either later this week or early next. Meanwhile, have a great day.
Thank you.